Good morning, ma'am.
Good morning. How are you?
We are all fine, though we are just locked down as you are. But we thought that this is the best way that we should have the different facets of law known through, firstly from Mr. Siddharth LUTHRA, then from you. There couldn't be a better way to make an entry for all different aspects of law. And the fact that you have made these strings, it looks that it will be a very fantastic session, and people were always willing to hear you. As the topic for today is, everybody on the platform knows, regarding law, the manner of compensation, as well as rehabilitation. Land has always been closer to the heart of everyone. Maybe it is a small time land holding or a big time person who is into this investment. And everybody whose land is being acquired gets jittery on that aspect, and then he has to contact a lawyer. Yeah. And if he has a lawyer like you, nothing to beat it. And today, when people will hear you on different aspects, what are the entire gamut of the land acquisition, how the land is acquired, how you can be rehabilitated, what is just and fair compensation, because land being acquired is on different levels by NHI of late, and the latest judgment of the Indore development. Hearing from you would always be a pleasure. Ma'am, over to you. We can start off. We are at 11.
Right. Thank you. Can everyone pin my video and mute themselves if that's possible?
We muted everybody.
All right. All right. Good morning, everyone. Land acquisition is a subject which a lot of people find a little complicated, but in fact, it's one of the, once we know aspects of land acquisition, you'll find that it's actually a very simple subject. Now, what's most interesting is land. How important is land as compared to human rights of, say, freedom of expression, freedom to form associations, all the freedoms which are including right to equality, Article 14, 19. Now, question would be, is right to property at one time in India, right to property was a fundamental right. It is no longer a fundamental right. And for that, we have to see when civil rights movement started, when the various thinkers like Hobbes, Locke, Rousseau, Voltaire started forming what is society, what is the state. Insofar as Locke said, he said really it's basically to protect property that a state is formed. And Abraham Lincoln's quote is what I'd like to begin with. He says, insofar as government lands can be disposed of, I am in favor of cutting up the wild lands into parcels so that every poor man may have a home. There's something which either Rousseau or Voltaire said, who says that, look, the first man who said this land is mine and the second man who believed him are the persons who are responsible for forming the state. In COVID times, we are coming to realize that neither land is ours and the environment is not just for us, it's for everyone. When the blood is in your veins, returns to the sea, and the earth in your bones returns to the ground, then you will remember that this land does not belong to you. It is you who belong to this land. John Locke. John Locke is considered to be one, as far as the United Kingdom is concerned, he's one of the greatest political thinkers. And as in United Kingdom, he, and in France, Rousseau and Voltaire, that shaped civil rights, that shaped what the modern state is. They said a theory of private property that justifies individual title on the basis of labor is actually what is property. Though the earth be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whoever then he removes out of the state that nature had provided and left it in, he hath mixed his labor with and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it had by this labor something annexed to that excludes the common right of other men. So this is how we can say, this is mine and that is yours, and that is the state's. Now, the state has always had the right, which is called in the US eminent domain, an expression which we also have adopted over the years, or land acquisition as recognized in the UK and in India. So what is eminent domain to be exercised for, and how far should the state go in exercising eminent domain? If we need, and in today's day, we need infrastructure projects, we need dams, we need roads. Take the Delhi-Chandigarh highway, how much land would have been acquired for it? Take the Agra expressway, take the Agra-Lucknow expressway. How much land, how much rehabilitation, how much resettlement, how much we changed the lives of the farmers that were tilling that land. This right of eminent domain has to be exercised with balance. And the US in Article 5 says, no person shall be deprived of property without due process of law, nor shall private property be taken for public use without just compensation. In India also, the law has been similar. Our old act was in 1894 Act. When the 2013 Act, it had been in operation for just 119 years. Now, when the East India Company and Great Britain ruled over us, at that time, this old archaic Land Acquisition Act of 1894 served its purpose. But did it serve its purpose 50 or 70 years later? To my mind, not. And that's why we have the 2013 Act. 2013, when I would, on the conclusion part, I'll come to the amendments being proposed in 2014, which, as I will discuss later, have not been brought into law. And why was it required? The new act became necessary because you need to have fair processes. You need to give principles of natural justice a voice. You need to have an adequate compensation. Affected parties and their land ownership needs to be looked at. In Keshwanand Bharti, and after that, the 44th Amendment of the Constitution came into being in 1973 Supreme Court. The question was whether compulsory land acquisition would infringe right to property. Right to property was removed from the fundamental rights and it became part of Article 300A. So it went away from fundamental rights. Now, what were the grievances against the Land Acquisition 1894, which was sought to be redressed by the 2013 amendment. So one was just everything was public purpose. You name it and they gave it the name of public purpose. During, for example, the time when the chief minister was Mr. Saab Singh Verma, he felt that we needed to form some infrastructure for the villages. So even though there was a master plan in place, he envisaged what was a mini master plan for each village or each block of villages, so that there would be a school, there would be infrastructure, there would be playgrounds, there would be maybe medical facilities. That was struck down by the Supreme Court in Deepak Bhardwaj. I may discuss that later if we have time. Then adequacy of compensation. In India, as we know, compensation is a very vexed issue because sale deeds sometimes reflect even a 1/5 of the land price. If sale deeds are taken as the marker, then the land prices were so abysmally low that people were being deprived of their land at a pittance. And I'll give you one or two examples, including the one of land near Hyatt Regency, which was acquired as recently as in the 2000s. Then public purpose. Supreme Court discusses this in Munilal as well as in Aflatun. I think Aflatun's 1973 Supreme Court. Public purpose, planned development of Delhi, planned development of any city. That was a sufficient public purpose. You didn't even need to show public purpose, just this definition. If you needed it for slum dwellers, you called it public purpose. If you needed it for residential, you called it public purpose. If you needed it for setting up some commercial complex, you called it public purpose. So public purpose became this stick to beat the people with, by which land was acquired without there being as much justification and acquired under emergency clause. Now, one of the aspects was emergency clause being invoked so that section 5A, which calls for hearing objections of people, that neither there is a public purpose and that their land should not be taken, was then dispensed with. And most judgments during that period of the 70s, 80s, 90s, public purpose and dispensation of 5A was upheld by the courts. Now, in this background, there have been agitations in various parts of the country, but I'll discuss only 3-4 because the idea is just to discuss compensation in some detail in this. Now, one of the most important judgments, and these judgments had social and political overtones. So the Narmada Bachao Andolan was basically to save people living along Narmada. And when I discuss this, and I discuss the 2013 Act, one of the important aspects is the right of tribals. Tribals live on the land. The land may belong to them, they may be using forest land, they use forest produce for their survival. The moment such lands are acquired, these persons become without a livelihood. These persons become roofless. Suppose they own the land. Even then, even if they get some amount of money, that money in their hands is frittered away, and then you have jobless people who've given into alcohol sometimes because they've suddenly got cash monies, and also people who lived in communities. In those communities, they had their family, they had their infrastructure. You couldn't even sell out of the tribal land. But the moment you had land acquisition, all that went. Now, Narmada, actually, there were huge protests. This was envisaged by Nehru so that people of Gujarat, Madhya Pradesh, Maharashtra, people along Narmada River who were being displaced, formed this movement under Medha Patekar. The dam was several dams, including the Sadar Sarovar Dam. And in fact, it was envisaged during Jawaharlal Nehru's time, 1947. He calls the dams temples of modern India, because he looks at development being necessary, which is true. But what we have to look at is a concept of sustainable development, and it can't be even more true in COVID times than it is at that time. So in 1961, he starts going ahead with Sadar Sarovar plan. Now look at there will be 2 or 3 timelines which according to me are very important. One is that the World Bank envisages an interest and says it will fund it with thousands of dollars of aid. And then there are these protests, and World Bank tries to get, say, rehabilitation, resettlement, and finally pulls out of it. So I'll share the timelines. Some of the important timelines are what I have given in this. What happens is the matter goes to the Supreme Court. The Supreme Court grants a stay in the first instance. Then after several years, I think it was 6-7 years later, and there's a World Commission on Dams. Nelson Mandela gives his report, and in 2006, finally, it said, work on the dam has to be resumed, go fast. Then what is pertinent is the height of the dam is increased. Many more people are displaced. Many more people are displaced. But the issue in the minds of academics and environmentalists have still been, were they displaced for good reasons? And was that height required? Or would the lesser height have been sufficient? The popular opinion is that lesser height would have been sufficient. Now it displaced 250,000 to 3 lakhs of people. Of course, this translates to almost 100 acres or 37,000 hectares of land. But it did give water to 40 million people. It gave irrigation to Gujarat. It gave water to a drought invested area like Rajasthan. It gave electricity. It gave money to the state. Question is pros and cons. Infrastructure is necessary. It should be sustainable development, and it should be in such a manner that you have to do the bare minimum displacement. Now, how do you compensate those thousands and thousands of villages which had to be removed for the dam? Now, there are people who, you're close to your next door neighbor, you're close to your next friend in villages. How do you, if one person is given replacement in Gujarat, another person is told you go to Madhya Pradesh, or someone's given money, is that sufficient? Is that enough to rehabilitate and resettle, or have we uprooted them and have made them homeless people for the rest of their lives? This whole discussion, Medha Patekar did a great service, although her Finally, she had lost the case, but the fact is it brought to forefront the requirement of sustainable development. The Tata Nano project in Singur, West Bengal, is even more interesting. So the Tatas, Ratan Tata had wanted to have his pet project, the nano car, and land was taken at Singur. It's 997 acres, I think. And there were agitations, there were protests, went to a single judge of the Calcutta High Court, where they lost, went to division bench, where Tata succeeded, went to the Supreme Court, where Tata lost again. Just two judges, Justice Gowda and Justice Mishra. Justice Gowda says, for different reasons. One says, can't see a public purpose. The other says, I don't see 5A dispensed with fairly. 5A should not have been. So on these two grounds, the acquisition, in the meantime, the Tata Motors said, we look at an alternate land in Sanand, in Gujarat. And of course, they moved the project. This was when Ms. Mamata Banerjee was in the opposition. In a sense, it was her flagship agitation and really paid her high dividends. The question here is, why did the acquisition fail? It failed because the consideration was poor. It failed because there was no consent clause when it was being taken for a company, aspects which have been rectified in the 2013. There was no rehabilitation, there was no resettlement, and food security was not considered. And this is one of the laudatory purposes of the 2013 Act, that where there are multi-crops irrigated land, then it should, as far as possible, not be taken. Now, what happened is history, that Tata moved its nano project to Gujarat. But who was the loser? In a sense, the state of West Bengal was the loser. State of West Bengal lost a brilliant project by one of the premier companies of this country. And one would have adequately compensated if the law envisaged that. And more important, it lost so much employment. It lost, thereafter, the history says that these farmers then tried to look for alternate, after some time, somebody else to acquire their lands. But that didn't happen. And therefore, in a sense, it is a lost opportunity, though the political repercussions were immense, positive for some and negative for some. In all, if we'd had the 2013 Act, perhaps the project would have gone through very smoothly. Now look at the Noida development project. In Noida, Greater Noida, land was acquired under planned industrial development in Gautam Budh Nagar. It's almost an amount of 1,455 acres of land. Urgency clause was invoked. Again, the question was, in today's day, if it had been under the new Act, this would not have been, because it was being taken for companies. Section 102 would have been looked into, where if a company is given the land, then 40% of their pay up and profits would have reverted to the farmers. Now, several of the writ petitions, since very many villages were acquired, in first instance, Supreme Court upheld with regard to several villages. Then there were other villages like Sabari, where the acquisition was quashed. In the meantime, the investors and builders had already gone ahead with home buyers. So there were home buyers whose stakes were there, small home buyers. There were farmers who were agitating. There were the investors who had put in a lot of money, whose projects were quashed, some of them. And urgency clause was clearly not fairly invoked, which was being done as a standard. What happened was that the Supreme Court upheld most by saying that enhanced compensation of 64.7% to 1,400 per square yard, so that the farmers became happy, but the investors did lose out, the home buyers did lose out, and Greater Noida and Noida authorities have not kept this in mind, which has, to my mind, not been worked very fairly by the state authorities, but that is part of an ongoing issue, and therefore nothing finally can be said on this. The South Korea there was a project implementation requiring 2,900 acres. POSCO company was to take it over, but the question was, there was opposition by people. The NC Saxena committee said that Forest Rights Act not taken into account, and ultimately POSCO project moves out of India. Do we want these projects to go away if they are indeed for the interest of the people? We don't want them to go away, but we also want to look that they don't impact. And that's why now assessment of a social an attempt in order to have an assessment of the entire situation. Where should the land be acquired? How should be acquired? How do we address the grievances of the people? How do we provide them safeguards? How do we provide them settlement? How do we compensate them enough? How do we ensure that the urgency clause is not abused? How do we ensure that, for example, acquisition for Delhi-Agra highway, Agra-Lucknow highway, they've been plantation ordered. The plantations ordered in terms of the environment guidelines and enactments. And that now this results in the present enactment, the LARR Act 2013. Now, the attempt is, it should be transparent, there should be consultation, there should be rehabilitation and resettlement, there should be least disturbance. Of course, there will be disturbance. And our projects and infrastructure in India has been growing with leaps and bounds from the 1990s. So how do you ensure just and fair compensation? The government may actually want to, when it enacts, say it wants to give just and fair compensation. But when it comes to practice, the collector will always try and be conservative, overly conservative, give as low a rate as possible. Various amendments which had come into the Land Acquisition Act over the years of 1894 have also been brought in here. So market value means the value of land determined under 26. Some of the guidelines in the old judgments have been incorporated, including the importance of the sale deeds of the locality, of the area. This earlier proceeding of giving the agricultural land and saying it's what class of land, all that has been given up. And one looks at various parameters of seeing who is a person interested in the award. Now, this is the manner in which the 2013 Act improves on the 1894 Act. Look at compensation. We can go on further on it, but one aspect which will come out in this slide is the social impacts assessment, which is mandatory, except in cases of urgency, and public purpose is somewhat sought to be described under section 2. Then another aspect which comes out is for rural and urban. For rural, it may go from 1 time to 2 times the market value. For urban, it will be 1 time, and solatium will be, instead of 30% under the old Act, it will be 100%. Rehabilitation and resettlement attempt is that it should be mandatory. Now, if a brief look at some important provisions, they're very similar, except for the requirement of social impact assessment, rehabilitation, reassessment, and resettlement, and compensation, and greater attempt at actually taking the market value. So how is that being sought to be done? So the sections which deal with compensation are 26 to 29, and 102 is important if it's being given to a company. 80 is important with regard to interest. So this is pre-notification social impact assessment conducted by the appropriate government. And this report to be examined by independent expert group. So all this becomes significant. The question whether if that's not complied with, whether it will fail, is something which the courts will have to look at. I will come later to section 24. That's actually long enough and a large enough subject that it may require a separate webinar. But in this, I'm just going to concentrate now further on the compensation, which, apart from the value increase and the solatium increase, it's majorly similar to what was there in the old Act, but these differences are very, very significant. And the award for rehabilitation and resettlement, which is given in the second schedule, which can provide for employment, can provide for some 3,000 rupees for first year per month to be given, can provide for 5 lakhs or 2,400 over 20 years, 2,000 over 20 years, are something which may be significant and are a great improvement on the earlier Act. Now, the illustration makes it very clear. It's very simple. If rural land is 10 lakhs, then multiplying it, it need not be only by 2. It's 1 to 2 as envisaged in the first schedule. And then you add the value of the assets, you add what is growing on the land, what cultivation is there, etc. And in urban areas, it will be 1 time. So, and to both, you will add solatium. So in cases of rural land, it may actually be 4 times the market value if the state gives you twice and the solatium doubles it. So that's how the values will come. If you can see it, it's very simple in the slide. Now, these are the various enactments. Section 26. The collector shall adopt the following criteria in assessing and determining the market value of the land, namely the market value, if any, specified in the Indian Stamp Act for the registration of sale deeds or agreements to sell, as the case may be in the area where the land is situated, the average sale price for similar type of land situated in the nearest village or nearest vicinity, consented amount of compensation as agreed upon under subsection 2 of section 2 in case of acquisition of lands for private companies or for public-private partnership projects. Now, very interesting, Supreme Court had ruled in various ways, including in 1909 Supreme Court, that if two villages are near each other, I think it was the case of Mahipalpur and Rangpuri, then you can't just say that because they are joining, the rate should be the same. Subsequent various High Court judgments justified that if there are two adjoining villages, for example, Jasola and Bhapur. Now, if you look at Delhi, Jasola and Bhapur means New Friends Colony and areas next to that, both of which are extremely expensive rates now. But at that, initially, they were looked at by the collector as being very, very different. So the High Court, Delhi High Court Division Bench in RFA determined to the contrary. There are many, many judgments of many villages which have looked at this. Now, one of the other aspects which will be looked at is section 28, market value after 26, damage in inspection, damage in acquisition. And if people are being made to change their residence or place of business, that'll be looked at. It's interesting in the US, for example, they would look at the fact, so suppose your house is worth 10,000 where it's located at market value, but the Olympics are coming there. Then they'll look because of Olympics, it's going to be 50,000 or 5 lakhs. And that aspect's also looked at, which isn't in India. But most countries look at market value because their market value, there are no hidden figures. So if this is the value, there won't be a cash component. And therefore, most of them are compensating or are looking at market value that rural and 1:2 ratio is not there in most other countries. Now, determination of value of things attached to land, these would obviously be looked at, these additions, but additions which are made after the initial notification under 11, which is the old 4, would not be looked at. Now, 30 is laudatory, this solatium. Solatium is your emotional loss, your compensation, your hardship, your unhappiness at the acquisition. Now, you will see how the land acquisition collectors are being so conservative in awarding compensation. So, district judge, in this case of Konkan Railways, awards 4 rupees enhanced. Collector gives 4 rupees. District judge enhances to 192. High Court reduces it, giving 85% deduction. Supreme Court says 85% deductions not good, not fair. It's for laying a railway line and reduces the deduction by 20%. So you'll see several examples of this. one of the criteria, most important criteria, has been sale deeds in the past, and they continue now to be virtually to be incorporated and brought in statutory under Section 26. So you look 3 years before the sale deeds of up to 3 years ago, and what if you don't find sale deeds of that village or that exact locality? Then you look at nearby sale deeds. Now, 3 examples of Punjab in Haryana High Court: enhancement to 71%, enhancement to 444%, enhancement to 552%. This just shows that despite the objective of the Act, despite the laudatory purpose of the enactment, compensations being awarded by the collector still are abysmally low. And then you come with the criteria, you show circle rates, you show stamp act rates, you show for 3 years, half of the highest sale deeds, you look at their mean. So it's been sought to be categorized such that the room for discretion, the room for arbitrariness is reduced. In this Krishna Kumari Uppal, it's a judgment, in fact, by Justice Sikri when he was in the Delhi High Court. I was one of the counsels. I've done several cases on land acquisition because for tons of years, I was senior standing counsel for the land building department of Delhi government and in the Supreme Court. So in Krishna Kumari Uppal, the land just next to Hyatt Regency was sought to be acquired for the Bhikaji Kama Center. And guess what was the rate? I think it was 2004. It was 47 rupees a square yard that was awarded by the collector. The Delhi High Court thought it was very unfair, and the amount finally which the court managed to cajole the state to come up to was 11,500 per square yard. So from 47 to 11,500, I know how many fold increase that is. Landowners submitted, sale deeds were not. Landowners failed to submit side plan. So sale deeds, certified copies of sale deeds, earlier they would say it's necessary to produce either the seller or the buyer, but over the years in the old Act, the court started accepting certified copies unless there was something questionable about them. So this in the rehabilitation and resettlement package, which is the 3rd schedule, these are the 6 possibilities: subsistence allowance, jobs if created. There's a judgment on jobs where the court has said that it's not mandatory to give jobs. I think it's NIDA. I'll just refer to it in a minute. And 5 lakhs for family or 2,000 with inflation. Plus, if house is lost in rural area, Indira Awas Yojana. If lost in urban area, plinth area shall be provided. Transportation, resettlement. This is, again, much to be appreciated in this Act. Then there's social impact assessment. So you can see what it is. The urgency clause. The urgency clause is 40, is similar to 17.1 and 4. 17.1 and 4 was abused in the past, so they've tried to cabin crib and confine the urgency clause. And this is good because this gives room for hearing objections by those who are aggrieved and who are interested and who are adversely affected. The whole purpose of an urgency clause would be lost if everything was urgent. Then you won't, something which is an exception cannot become a rule, and that's what is important. This judgment of Deepak Bhardwaj I just discussed. In Praveen Jain also, there was a quashing of the urgency clause where 200 acres of land in village Palaswa, Jahangirpuri was sought to be acquired. Now, the unfortunate thing about this is that you cannot keep, even with urgency clause, something remain pending in the court for 16 years. That's too long. And then the court quashes it on non-application of mind. The fact is that in Delhi, I was counsel in both these cases. Now, this, why are we going back? Sorry. Now, the judicial pronouncements on this could be a separate subject virtually, because the Indore Development Authority runs into some 500 pages. In short, if I were to summarize it, it would be that Pune holds in favor of landowners for whom compensation not paid or possession not taken. The language as compared to the earlier act was physical possession. Now, the court has distinguished it in that sense from Panchnama possession. But subsequently in Indore development, which is as recent as March of 2020, the first Indore development is February, second is March, and Indore development decided by a bench of 5 judges, the word or used in section 24(2) should be either nor or and. So the court has interpreted it to say that even if amounts are deposited in the treasury, that is good enough. Whereas the earlier view was, and the way, unless this interpretation is given, the way it read was that actually it should be tendered to the person or then deposited in court. So that's how the expression is. I'm not going to go too deep into Indore and Pune, because if I keep going into it, as I said, we will be holding you up for the next 2, 3, 4 hours. And that, I'm sure, you'll find too tedious. So this, in short, is what is said by Pune, Indore, and again Indore. And the last word is by the 5 judges bench of Indore. So that's the final word so far of the Supreme Court. Whether there will be subsequent looking again at the section 24 and 24(2), but there's going to be a floodgate of proceedings on it. Now this Union of India versus Tarsem is very interesting. Under the National Highway Act of 1956, where a lot of acquisition was being made, it was partly sidelining this grant of 100% solatium and interest, which is there under the 13 Act. But the Supreme Court said that the National Highways Act was violative because the individual cannot be wronged in the manner denying him solatium and interest under one of 2 acts, and therefore the 2013 grant of solatium in interest would inure to the benefit of people. There have been several judgments on this, on 11A, including Padma Sundara Rao, State of Maharashtra, Madan Modi Ratan Estate, which repeats it, that stay for inures to the benefit. And it also said this in perhaps the full bench of Balakram Gupta, probably decided 1989 Supreme Court, it's saying the same thing. Private land of citizens without granting any compensation has been repeatedly held to be violative of Article 14 and 300A. And in Neera Devi, which I referred to earlier, landlord whose land is acquired for construction of railway cannot claim a job as a matter of right. So 50,000 acres of land in village Chhatarpur. Actually, it is in 13 South Delhi villages. And this became subject matter of so many proceedings, including Balakram Gupta 1, Balakram Gupta 2, Balakram Gupta, subsequently Delhi administration versus Gurdeep Singh Uban 1, Gurdeep Singh Uban 2. I was the counsel in some of these matters, the Gurdeep Singh Uban and the others. Now, there is no binding recommendation of the expert group. So this, in fact, it should have more teeth. If you are having an expert group, if you are having a assessment, a social assessment, then there has to be more teeth with it. Public purpose still remains somewhat vague, and there is a scheme that scheduled caste, scheduled tribes, if they are removed, then there should be some guidelines that if they lose their land, then some additional compensation, but there is no monitoring body for this. Now there's an amendment bill of which I referred to, 2015. This bill has passed Rajya Sabha, Lok Sabha, but there was no majority and therefore not passed in Rajya Sabha. There was an ordinance, the ordinance lapsed. However, in certain states of the BJP, there have been certain amendments, as you will see, Gujarat, Telangana, Maharashtra, Tamil Nadu, some aspects in order to emulate, to reduce the rigors of the 2013 law. Should the rigors be reduced or should they not? In a country like India, to my mind, the rigors to a large extent have to be kept because we have to ensure that that India, which has 70% rural population, doesn't get displaced, they don't become homeless, they don't become jobless, they don't become roofless. So to some extent, we do need a very rigorous law. That, according to me, is the need. But having said all that, what I want to conclude is by saying that we will see a lot of legal proceedings on this 5-judge bench decision on Section 24(2) in the years to come. Insofar as compensation is concerned, as the Act presently stands, to my mind, many of the disadvantages of 1894 old British archaic law have been corrected. I hope that you found the subject not too boring and not too complicated. To my mind, we will have more and more infrastructure projects, and therefore the Land Acquisition Act is a legislation on which we will see more and more. Thank you.
Thank you, ma'am. We have questions posted in the chat box. We will take one by one. And
Okay.
It was a session we cannot express in words. The entire gamut, the Supreme Court took 500 pages to explain Section 24. I thought if you could have curated that entire judgments in such a way, the judgments would have become easy.
All right. Why don't I do that in one or two lines for you? Basically, what Pune said, and so what Pune says is that if you just simply deposit money in the treasury, or a portion of the major portion of the money in a treasury, that's not good enough. You have to tender it, or you have to deposit it in court, either under 18 or 31. But what, just let me just take that out. But what Indore number 1 and Indore number 2 say are this. So Indore number 1 first says, I'll read para 16 of Indore. The Act of 2013 does not envisage the consequence of lapse of acquisition or non-deposit of compensation in court, and neither was it so provided in 31 of the Act of 1894. The provision of 24 thus does not contemplate deposit of amount in court, in our opinion. So the whole thing was, the argument in Pune was, if it's to inure to that person, you have to actually tender it to him. You're depositing it in treasury is not enough. Second, even if you tender it to him, he refuses, then you have to deposit it in court. But the way the court has, the way Indore, the 3-judge bench of February said was this. The expression paid, and this is para 41, 55, which according to me, and 72 and 218, which are relevant. So the reason I'm just quoting 5 paras is because it may make it too long otherwise. Para 41. The expression paid would mean in section 31(1) of the Act, as soon as it was offered and made unconditionally available, merely if a landowner refuses to accept it, it cannot be said it has not been paid. Para 55 says, in the instant case, when we give the plain, natural and grammatical meaning to the word paid, tendered, which has been used in contradistinction to the words deposited in court, it is clear that tendering payment would not include deposit in court, in that it is only when payment is refused that the same is deposited in court. Obligation to pay is over. So the court says, you've done this, that's over. Whereas Pune said, no, the obligation does not get over. It also says Pune is per incurium, and the court goes on to say, para 72, deposit in treasury is stipulated under the rules made with reference to a constitutional provision as sorry, vice. Sorry, 55 of the 1894 Act. So what happens is sometimes in the treasury there is a recurring account, say of a development authority. That account will have, say, 20 crores. Now that 20 crores can't be used by, say, 20,000 people. But anyone who wants to use it, they can move applications and get it. Now the question is that enough, or should they have a earmarked amount even in the treasury for that person? Now that's something which has been left a little vague, because the court says as long as they've given amount in the treasury, it's enough. Sorry. So the way that they have interpreted it is that if the land is acquired 10 years ago, compensation is, no compensation given is not enough for under the new act. According to this interpretation, no compensation either tendered or deposited in treasury is what is considered. So therefore, the expression used in 24(2) in its amendment, the word or has been interpreted to be nor and. So I'll just show that. Provided that where an award has been made and compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiary, so this one's fine. Now 2, notwithstanding anything contained in subsection 1, in case of land acquisition proceedings, and I'm reading 24(2), initiated under the Land Acquisition Act, where an award under the said Section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken or compensation has not been paid. The court has interpreted or as nor and or and compensation. So it wants possession and compensation, and it says, so it uses the word and says both things have not been done. So the court then interprets that possession taken equivalent to section 16 of the old act. The moment possession is taken, you have no rent. You are only entitled to compensation. So the way Indore 5-judge bench has interpreted it is different from Pune, where it says that if possession's taken, that's the end of the matter. And it also treats the compensation part as if compensation has been tendered into the government treasury, that itself is also compliance. So this is both aspects the court has interpreted in a manner to uphold the acquisition under the 1894 Act. So there will be a very narrow window of those persons left who will be able to utilize 24(2) to say that proceedings have to start afresh or you have to pay according to the market value under the new act. Now, one of the questions from Monita Mehta is, if the land is acquired for a public purpose, is not utilized for that purpose, and is lying vacant, can the landowner from whom the land was acquired claim it back? In such a case, is the landowner under an obligation to pay back the compensation to the government? So clearly, if the land is not utilized for that purpose, there are many judgments even under the earlier law on this, which said that if the acquisition to start with was not for a mala fide reason, but it was for a bona fide purpose, but ultimately it was utilized for some other purpose. For example, in the metro or other cases, almost 80% of it was allowed, and the question was raised in the Supreme Court. I'm not remembering the citation just now. The court said there is no infirmity if even if some of the land has been used for some other purpose. The question here is, there is some limitation that if within 5 years it's not utilized. I think that is how the section envisages it. And that's how it comes. What is the other question now? What happens if possession has been taken, but admittedly the compensation has not been paid through any method? Would the acquisition lapse still notwithstanding? So if possession has been taken, the way the bench of 5 judges have said is then all you can get is compensation. Ultimately, you'll also be getting interest. When Pune was decided, Pune said that if compensation is not paid, then it lapses. But they are going by that old, I think it was UP Awas or UP Jal Nigam old judgments of 1996 Supreme Court, that the moment possession is taken, it's complete for all purposes. That's how the courts have interpreted it. Insofar as 24 is concerned, according to me, it's actually a subject for a complete webinar so that I can give you many aspects of the 500 pages, which I hope will not be incomplete just now, even though I'm trying to address some of them. Now, one of the questions is, once the statute under 24(2) uses were, or, and.
Ma'am, if you find it convenient, I can read the questions for you.
No, it's okay. And there being no challenge to queries just because of interpretation ingenuity, the apex court says were, or will mean and. Is it a good ground for a larger bench? You see, at the moment, the Supreme Court doesn't look to be in the mood for a larger bench because they've just decided it on 4th March. I think time will tell. To my mind, the plain reading could make it possible that subsequently the Supreme Court in a larger bench would look at this, because it has taken or to be nor and. So the fact is that this interpretation is perhaps trying to ensure that the amendment which has not come and has not come yet, which is the later proposed amendment, which wasn't passed, that projects which are being held up or acquisitions which are being done, where the compensation would run, for example, these 13 South Delhi villages, if the compensation which would be given would go into thousands and thousands of crores, whereas if it was done, if it had been upheld in Shivraj, would have been in lakhs or even in a few crores. will now go into thousands of crores. So in a sense, the exchequer saves a lot of money with this interpretation. So there will be state which will want to uphold it, and there will be individuals who would want to challenge it, saying that this interpretation could be re-looked at by a larger bench of the Supreme Court. Now, the last, this is Kshitij Sharma. Although Supreme Court has interpreted 24 that in order for the acquisition to lapse, both conditions need to be satisfied. Compensation has not been paid anywhere. Land has not vested in the government. But can there possibly be a case where the land has not vested from the time of the award? The stipulation of physical possession has not been taken, has been read as land must not have vested. I'm sorry, I didn't quite understand this question.
Ma'am, I will ask.
Yes.
I will unmute Kshitij. Meanwhile, Khushika Sethi asks, how to decide the ownership of a Lal Dora land? Can Lal Dora land be mortgaged?
Can Lal Dora land be mortgaged? See, this is more a revenue matter than land acquisition, but Lal Dora land, whoever is physically in possession would be deemed to be the owner. Now in Lal Dora land, because there are electricity, water, other bill, there will be proof of ownership. Possibly the banks would agree to take it on mortgage, to my mind, because the difficulty in Lal Dora is that there will be many claimants. There will be people who will try and take possession and show that they are in actual ownership and possession. So clearly anyone who will agree to take it on mortgage would look at the aspect as to how long has been the possession of the person. But this is something, because it comes in the revenue sphere, I would have to answer with a little more looking into.
I will ask somebody to post it on the chat box.
Yes.
And meanwhile, Monica Mehta asks, if the land is acquired for a public purpose, is not utilized for that purpose and is lying vacant, can the landowner from whom the land was acquired claim it back? In such a case, is the landowner under an obligation to pay back the compensation to the government?
Firstly, if you get the land back, you'll obviously have to pay compensation. At worst, we pay back except for the period when the state remained in possession. So you would get some amount. There's no question. You would be able to get deduction of some amount. The question then is, if it's not utilized, see, it's, suppose I acquire something for, say, making a road, and I never intended to make a road there. Then but because a purpose can be changed. But if I never intended to make a road there from the inception, and it was a bad exercise, then of course you would be able to get back the land. But if it was intended to make, and then the way of, say, your metro or your road changed, then to get it back would be more difficult.
Whether the market value and solatium, as per the new act, can be taken for pending acquisition?
No, it can only be under 2013 law. It can't be unless 24(2) comes into play, where they won't be. You will have to go under the old act.
And then Priyanka Mehta asked, what is the fate of the mortgager if the property is acquired by the authority after they have taken possession under the SARFAESI?
Yeah.
Supreme Court. SC hand over the properties, including of the mortgage, to any authority, since mortgager was not the party to the proceeding.
Sorry. Just will you repeat?
Ma'am, it's at 11:38. Meanwhile, I will ask Kshitij. Otherwise, Kshitij will say I've been sent to the back burner. Kshitij?
Yes, sir. A very good morning to you, ma'am. Thank you so much for such an informative lecture. I totally agree with you that the judgment clearly needs a separate webinar. However, only if you choose to answer it only for the sake of brevity, if possible. The section was very clear in terms of using the word or, which you already shared, but now it has been interpreted to mean as nor, either nor or and. That means both the conditions need to coexist, and only then would the acquisition lapse. Now, what I was wondering that when the Act came into being in 2014, and the Act itself says that whatever was initiated 5 years back, right? If in that case the physical possession has not been taken, then it would lapse. Now, obviously, when you do land acquisition matters, you do understand that they always, even before the award, they always make a panchnama. They always make the entry of the government as being the owner. So once the land has vested, there'll obviously be never any case law in real sense where it would actually lapse, because that condition possibly can never be met after 5 years.
You are absolutely right. You are absolutely right, which is why all those later judgments kept coming, saying Panchnama is not good enough.
Right, that's true.
And which is why the expression used in the 13 Act is physical possession.
Physical possession, yes. So that is correct.
But the Supreme Court in this judgment of Indore interprets physical possession as including Panchnama and says others will be trespassing.
It's actually not. I mean, I was wondering what probably a factual scenario would be where it would actually lapse, because there will be probably no case where there is no Panchnama. There will be Panchnamas in all of them. So anyway, but thank you, ma'am.
You're right. I mean, you are right. I hope at some point the court feels this needs to be relooked. But this is how it is. We can go over I was telling Mr. Chatra this when we were starting. He said, no, talk on compensation. I said, I can actually talk on Indore and Pune as a full webinar.
Yes, it can be talked. It absolutely can.
Yeah.
Ma'am,
so grateful.
In fact, ma'am, it is all because of you that we have been able to have the entire this thing in a 45-50 minutes.
Yes.
The judgments, even if we start reading, simplicity reading itself, any judgment takes hours and hours. It's you and your entire team who have created that PPT. The PPTs are wonderful. The messages on my mobile are continuing to pour in. The messages on the chat are also showing that the PPT should be shared, because they all feel that this is the best way. Whenever there is any trouble, they can just go through your PPTs and it will be very good for them. Amar Vivek asks, once the statute under section 24(2) of the Act of 2013 uses word or, and the Supreme Court in Indore case says it means and, there being no challenge to the same. What is your take to that?
I've just answered Kshitij on that. I mean, the fact is that a lot of colleagues, in fact, argued the matter. I was also to go and argue, but the fact is, we were really saying the same thing. All of us were saying the same thing, that the language seems so clear, and that Pune and Indore, which followed Pune, could not have differed from Pune. In that sense, Indore could perhaps have been said to be per incurium. They should have referred it to a larger bench if they weren't agreeing. But on the other hand, Pune has been held to be per incurium. So ultimately, we are lawyers. Till the next judgment comes along, we are bound by the five-bench judgment. That's all that I can say for the moment.
In the judgments, they also say similarly, you may hate me, you may like me, but you can't ignore me. So ultimately, it is a verdict which counts, which is the final word.
Yes.
Ankush Bansal has posted one question.
Okay, I'll just see.
I'll just see. Because till the message is spread, I'm reading that. Till then, another question posed.
If Sarpanch of a village gives funeral land, that is common purpose land, to some BPL families without any authority for residential purpose, does it fall under public purpose? So normally land which is common purpose land and which is meant, in this case, funeral land, normally it can't be given. Normally, Gaon Sabha land, some others such land, whenever it is sought to be given, it has not stood the test of the courts. So, and here he is saying if it is without any authority. But if Ankush wants me to look for a citation, I'll have to tell him. But otherwise, I've done one or two matters where Gaon Sabha land was sought to be given and the court struck that down.
Ma'am, it will be a botheration, but I've seen your team is doing a wonderful job. The questions which are left in certain gray areas, though it will be a botheration, we will ask that you can share that answer to that. We will post it. We'll post it in the group. Those persons who are not on our WhatsApp group, they will join in that process.
Yes, sure. Give me the questions and I'll answer them anyway.
Yes, whatever questions are left, which remain unanswered, with the question answer, because everybody knows that LUTHRA's team means everything. And the fact that we are seeing this PPT that shows the hard work which goes behind the actual show.
Thank you. Thank you.
Under the new act, compensation gets, this is by Rahul Lathi. Under the new act, compensation gets tax exemption under section 96, read with circulars 36/2016 of CBDT. Can this be extended under the old act? This question is posed at 12:10.
So I saw one from Rahul Lathi, which was
12:10, ma'am. 12:10.
I'm not getting that. 12:10. I got something at 11:57 from him. Is that?
I will ask Rahul.
12:07. Under the new act, compensation gets tax exemption under 96, read with circular. Can this? To my mind, no. To my mind, no. So the reason would be that and this is not necessarily part, compensation given for land acquisition, we'll have to just look at logically, as far as 96 is concerned, it gives an exemption. But then let's look at the old act and whether that would be counted. That we would have to look at the tax law and tax circulars with regard to the old act. So under the new act, it says, no income tax or stamp duty shall be levied on any award or agreement made under this act, except under section 46, and no person claiming under such award or agreement shall be liable to pay any fee for the same. Now the fact is, if you're being compensated for your land, it's not income in your hand. So even though there is no specific provision like 96 under the old act, it really isn't income in your hands. To my mind, being compensated for your house is not income, or compensated for your land is not income in your hand. But this we would have to look at more at the tax angle rather than me giving an off-cuff reply. I think section 96 must be encapsulating in a statute what is already there. Can this be the last question after this?
Pardon me, Saurabh Khurana has posed a question.
Okay, can it be the last one or do you want more?
Ma'am, Saurabh Khurana is posted at 12:11. Because we will be running short of time, we go by first question first. Otherwise, there will be heartburn. There will be heartburning.
No, we don't want heartburn.
The basic principle in our platform is fastest finger first.
Yes.
Please, Saurabh Khurana, who has been the secretary of our Bar Association.
All right.
12:11. Please guide severance compensation is to be granted on acquired land or unacquired land. What is the manner of calculation of the severance compensation? Hello.
So to my mind, severance compensation, I'll take out the provision, just take out the provision for severance. So according to me, it should be on the unacquired portion of the land. So because they give you a right that if you really want it to be acquired, then you have that right also. For example, if you have a property of 200 square yards and 100 square yards, say 50 square yards has been acquired, then the option in law will be that the balance, either you want it to be acquired or you get. So thirdly will be the damage under section 28. The damage, if any, sustained by the person interested at the time the collector takes possession of the land by reasons of severance of such land from the other land. To my mind, the fact that you will no longer enjoy your entire property to the same manner, so you would get severance, to my mind, for the as a compensation for the balance land, but I would have to look at it. But according to me, it would be for the balance, so that if you're taking away 40 square yards and you're left with 160, then that 160 would require compensation, or you can move the collector saying, please acquire all 200.
Maheshji wants your opinion. The amount has been deposited in treasury, but have never approached to take it. What is the remedy after the Indore development? Meaning, thereby he has accepted the acquisition. He has no choice, but he says what to go about it. How does he take that money?
So I think you can. They can go to the collector. They would be able to go even to the judge, the reference court. You can go in writ proceedings. To my mind, this would be the least of the problems, because they would be more than happy that you take the money. So the first and foremost would be the collector. So you could move the collector and ask, because then you have to give indemnity bonds and all that. So the first foremost, you would go to the collector and ask that you want the money. Second, if you don't succeed with the collector, you could go to the reference court. It can be whether you move for enhancement under 18 or under 31 or you haven't moved also, because you may want it with enhancement. The third would be by filing writ proceedings. So the first and foremost is the collector.
Hello.
Yes.
Hello. Ma'am. Anurag Jain says, please throw some light on judicial view about the proviso of 24(2). So far, it talks about the payment of compensation as per the compensation, as per the. I will just read.
I saw
Anurag
that.
Jain.
I saw that. I'm reading the proviso. The proviso says that where an award has been made in compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under 4 shall be entitled to compensation in accordance with the provisions of the Act. So basically what it's trying to say is, this is fairly simple in that sense that if there are, say, 100 persons and only compensation quad 20 has been deposited, and therefore really you haven't deposited for all, then for those 20 also this 24 will inure to their benefit. So those 20 will also be able to take the benefit of the enactment.
Ma'am, just for our facilitation, one of the participants, Mr. Kavan Dipender Singh, has posted for all our convenience. He says under section 194(2) of the Income Tax Act, the same is exempted.
Yes.
Question which was posed.
Okay. Yes, that's what I would have thought, but I said it'll be under the Income Tax Act, so I'm not 100% certain. But you know, it's not income in your hands. So I'm grateful to him. Thank you.
So that is the good part on this group, is that people do help PAN. They participate PAN India. They also participate positively also. If they have certain inputs, they give the judgments, etc.
Thank you. Thank you.
I'm just seeing if any other question is left. Rahul Lathi poses a question. There is a mistake in the Act of Section 64(2) subclause B.
Section
64 subclause 2, clause 2 subclause B. Limitation of 6 weeks to file reference starts from notice under Section 21. Section 21 is before the ward is passed. So, is it legally? So this is legally impossible.
This is legally impossible. That's right. There is
section 64 subclause 2 subclause B.
Yes.
Then he says section 21 is before the award is passed. Yes. So it is legally impossible to do.
That's right. That's right. That observation is correct. So,
again, another. We are through, ma'am.
All right.
One of the. Thank you for the wonderful session. But before we part, we have kept a pattern that you will have just to give a 5-minute wrap. How to make a mark within the profession. What is the take? How to develop the team who can help in such a wonderful fashion the way it has been done by your team.
So, a 5-minute wrap up on saying how to make a mark in the profession.
Well, mark would come subsequently. How to take the facts from the client, how to draft it, how to create a team like yours, and then how to make a mark. They're all consequential factors. It is just like one cycle falls in the cycle stand, the other cycles keep on falling.
Okay. Let me try and answer it to the best of my ability. So the first thing is, to my mind, for a younger lawyer, is an element of patience. What happens is that over the years, you will see clients who will waffle, clients who will not tell you the entire truth, clients who will tell you only that part of the truth which they want you to hear and the answer that they want to receive. And this is an attempt by them to make you not be able to think for yourself and think through their lens. So, you know, a client who really wants, for example, that he wants a particular relief, he will ask or tell you only that part of the picture which makes him hear that, yes, this is the relief you'll get. But to give a client relief, the first most important aspect is that you have to know the pros and cons. So one aspect is somehow to give that patience, give that assurance that first they have to share the entire facts with you. Then give you a chance to assimilate those facts. There will be cases where your knowledge of law There will be cases where your knowledge of law will be sufficient for you to give him an off-the-cuff answer. To my mind, it's better always, if you're not fully sure of your answer, to revert to the client and call him for the second meeting when you give him your view. Second, how do you establish, I think, motivation? How do you establish good colleagues, good associates? First, most important, respect them. People love to be appreciated, people love to be respected, and they deserve that respect when they work so hard. A lot of my colleagues, I may get tired at 11 or 12, and you have to lead by example. So you can't just say, I'm going off every day and think that they'll only do the work. You have to be participative in their effort. Second, you have to lead by example. So you have to work very hard and encourage, be open with them, learn, appreciate their feedback. Some of the feedback may actually, they will learn over a period of time that they have to give sensible, well thought out feedback. They can't just off the cuff say anything and waste their time and your time. So whenever they come, I remember many years ago, my father, late father, Mr. K.K. LUTHRA, had a colleague, Mr. Malviya, who'd been with my father for about 35, 40 years as his number one associate, and really a huge backbone. And I would rush to him because it was the easiest thing to do. So I'd rush to him and ask him, all right, Malviya uncle, tell me this. And say, have you read the Act? Have you gone through the Act? Have you gone through the commentary? Have you? If you haven't, go away. If you have, and then you have a problem, please come to me. But please be fully prepared when you come to me. So I think that's something which is nice. It's all very well to do research online and all that, but sometime to read the Parent Act. And I saw this very early on. There was a very heavy land sealing matter that I was doing in Bihar, thousands of acres attached to one of the sugar mills. And Mr. Bhushan, Shanti Bhushan came for the with me for the leading the arguments on the last day. And we sat, he took his flight, he was there at 7:30, and then he says, all right, if we are looking at this act, even though the only provision, and we had to look at one provision. He said, even though we only have to look at this provision, let's read it from section 1 till the end. Till then, we will have complete silence. You read the act, I'll read the act, and then we'll go on. And this, sometimes we short circuit things. We look at one section, which is important for us, and we forget looking at the act as a wholesome act. So some of these things which you learn to do, sometimes you can't really do them. Because maybe shortage of time. But while one is young, this is important. So it's like devouring a law. If you are interested in something, devour that law, read it and eat it up as if it's consuming you, and so that you can follow it and know it. Backwards, forwards, front, every way. And that is when you can develop nuances and new arguments. That's how I feel about this.
This question more specifically we had asked because they say that the law students and law interns who come from LUTHRA's firm are the best seedlings which grow into actually good plants and trees. So they wanted to learn what is the nuances for that. Thank you, ma'am. And we couldn't ask for a better thing. Only one request: if this PPT could be shared on my WhatsApp, I can post it on my group. Number one.
Sure.
And secondly, Sapanthi, who's also played an active role in the, organizing all this. I will ask Sapan to formally propose a vote of thanks.
Thank you.
And the persons who want to join our group, WhatsApp for latest updates, etc. I just gave an example why you should be part of the WhatsApp group or a Facebook page or an Instagram. Just because of one typographical error of 2 instead of 5 created the entire havoc. But ma'am is so popular that everybody again joined back. So once you are on the WhatsApp group and the Facebook page, you will immediately come to know what event is coming and how to go about it. And tomorrow we are having Mr. Puneet Bali, senior advocate, and his topic would be Law Kitchen. Law Kitchen means what are the all cutleries required to how to establish to be a good lawyer. Tomorrow, instead of 5 minutes wrap, we will have the entire kitchen, and let's see, the platter should be good. Do connect us. Mr. Sapan, over to you.
Please. Thank you, Vikas ji. Thank you, Geeta ma'am. Everybody know that Geeta ma'am is a senior lawyer. She had been vice president also of Indian Council of Arbitration. She is member of International Association of Family Lawyers. And ma'am LUTHRA is known for her work, legal work, and because she has appeared as a consul, senior consul in several matters on all facets of law, landmark, whether it is criminal, constitutional, arbitration, human rights. And I know that I have gone through your some time of your seminars also, where you have spoken as a speaker also on international level and on various issues, criminal justice system, etc., arbitration. There's much more to it. And I must thank you, ma'am, for today's session, that you have elaborately enlightened us for this land acquisition cases and the law about it. And we feel that on our request, you will accept our request for come again on some other issue also here on this Beyond Law CLC. So I must thank you and your team, entire team, for on my behalf as well as on behalf of Beyond Law CLC and all other participants to come and to for sparing this time for us, for enlighten us on this issue of land acquisition. Thank you, ma'am. Thank you.
Ma'am, just before parting, can we have the associate who was assisting throughout? We would like to see the asli chehra samne aaye.
So, Varun Diwan has been assisting, Pratik Yadav has been assisting. In fact, he's from Chandigarh, he studied in Chandigarh, his schooling. And my daughter Shivani has been doing it. So,
somebody who is sitting adjacent to you, rest of the persons we have come to know, but the person who is sitting next to you, we would like that person to come.
This is Shivani. She's my daughter, and she.
She has to come again. Shivani has to come again.
No.
Thank you to Shivani. She has acted like Shiv. Help us to come out all the troubles which were there. Thank you. Whatever glitches it could have come, she has resolved it. Thank you, Shivani. And thank you, ma'am.
Thank you.
Okay. And tomorrow we have also a session in the evening by Mr. Pushpinder Kaurav, the Advocate General Madhya Pradesh, as well as Tanveer Ahmed. They will speak on the murder trials. Thank you. Stay connected.
Thank you. Wonderful. Yes.
Thank you, ma'am. Thank you
so much. Thanks.